All right, thank you. Please be seated. All right, we're ready to go with City of Palm Bay versus Wells Fargo Bank N.A.
May it please the Court, my name is Andrew Lannon. I represent the City of Palm Bay. At the table with me is Jim Stokes, the City Attorney. I'm the Deputy City Attorney, and also Nick Samatellis, City Attorney Emeritus. I'd like to reserve 2 minutes for rebuttal, please. Your Honor, the case involves one issue, which can be summarized as follows. Does the City of Palm Bay, under its home rule powers granted by the Florida Constitution and Section 166.021 of the Florida statutes, grant the City the power to enact an ordinance which supplements the code enforcement statutory scheme set forth in Chapter 162 Florida statutes in the following way: by making its code enforcement liens deemed to be co-equal to state, county, district, and municipal taxes, superior in dignity to all other liens, including the appellee's mortgage.
Let me ask you this. Without this ordinance, who would have the superior lien? The lender or the city?
Under this ordinance?
Under the facts of this case, if you didn't have this ordinance, who would win?
Oh, most definitely the appellee.
Okay. And why would they win?
They would win under first in time rule, the common law principle.
All right. Has that rule been codified?
Yes, it has. Section 695.11.
All right. So if you apply just the state, if you didn't have this ordinance, and you just applied a state statute, then appellee wins.
Well, yes, Your Honor, but I would
like you agree with that?
I do agree with that.
All right. Now, if you didn't have the state statute and you just had the city ordinance, who wins?
The city.
Okay. Now, if you have both, which takes priority?
I believe that the city ordinance, because if you took 695.122, the first in time principle, that is, if you took it in a vacuum, then all liens would be based upon recordation. Now, if you notice, it says in that statute, all instruments shall be deemed to be recorded in the order that they are filed with the public records of the county. Now, that does not take into consideration the tax liens under 197. It doesn't mention that. It says all instruments shall be noted in that fashion. It doesn't take into account 159.17 utility liens.
But that's a situation where the legislature has created an exception to the rule.
I understand. Those exceptions aren't delineated in that statute, and that's why if you took that statute in a vacuum, yes, you would come to that conclusion. But I respectfully disagree with respect to this lien and our authority under the, because there are other arguable provisions.
But in a special assessment lien, what you'd have then is you'd have two state statutes which appear to be in conflict, but then you take the more specific one over the more generic one, correct?
I understand.
All right. So where's the contrary state statute here?
The contrary state statute, I would say, is 197.522, the tax deed statute, that says in the event of a tax deed sale, the appellee's mortgage will be wiped out, but yet the city's municipal liens, all of them, code enforcement, nuisance liens, special assessment liens, utility liens would survive.
This isn't a tax deed sale, right?
I understand. But I'm saying the deference that this legislature provides to municipal liens is clearly demonstrated there. And that's why I said if you took that one first in time rule statute in a vacuum, by its express provisions, says all instruments are deemed to be recorded.
Well, I understand your argument that as far as the tax deed, the city code enforcement board lien has some power that doesn't exist for a mortgage from a private lender. But if you turn that around, y'all can't foreclose on a homestead property, and a lender can.
No, and going to the Florida Constitution, which prohibits us from doing that, as you know, that same Florida Constitution authorizes us the rights to enact legislation like this under our home rule powers. And the Constitution is certainly greater than the first in time statute.
So I guess my real question is how is your code enforcement, how is the ordinance in question not in conflict with 695.11?
I think that it's not in conflict because when you construe it as a whole with all the other the statutes and constitutional provisions that I cited, and I will reiterate in my argument here, that if you take all those things together, it's clear that the legislature's purpose, I'm sorry, let me go right to that. the manifest intent of the legislature is that all municipal liens are superior to mortgages. And I cite in support of that Florida League of Cities, Inc. versus Department of Insurance, 540 Southern 2nd, 850 at 857, where they say, the general rules and manifest intent of the legislature will prevail over the literal import of the words used by it. The literal import of the words used in that Section 695 deal expressly with, it says all instruments. So if you take that in a vacuum, the literal import of the words are that it applies to everything. But when you construe all the statutes together in pari materia, you come to the conclusion, as we laid out in our argument, that the city has the power under its home rule powers to enact an ordinance in this area. And that the manifest intent of the city, of the legislature, I should say, is to make all liens of the municipal entity here in the city of Palm Bay superior to contract liens like a mortgage.
I'd like to actually address a preliminary issue, and that is that when you go to paragraph 5 of the judgment,
Yes, Your Honor.
the court says, lastly, the court finds that notice should have been provided to the plaintiff when these code enforcement liens were recorded in the public records to avoid a due process issue. Now, so the judge, that was an alternative basis for the judge's ruling.
Yes, Your Honor.
You did not address that issue in the initial brief. Therefore, that there is no argument being made in terms of error. Why isn't this an affirmance based upon that alone?
Okay. Well, Your Honor, I think that the Mennonite case is a red herring.
No, you're getting to the merits. You haven't argued the merits in your initial brief. So you don't get to come in at oral argument and argue the merits of that issue.
I understand your position, Your Honor. I respectfully disagree with.
Well, why do you disagree?
I disagree in that the basis for the argument is based upon the Mennonite case, which is distinguishable from this case.
All right. So you want to be able to not address it in your initial brief, come into oral argument, and make an argument on the merits. Correct?
Your Honor, I would like to.
Okay. All right.
So just, I see we're very familiar with the facts of the case. I'd just like to highlight some clear points. On March 6, 1997, the city enacted this ordinance, 97-07. The municipal purpose is stated in Section 1 thereof, that it's there to promote, protect, and improve the health, safety, and welfare of the citizens in Palm Bay by creating a board with the authority to impose fines and other non-criminal penalties whenever there's a violation of the city's code of ordinances. And then Section 5 sets forth the priority of the liens, stating that the Code Enforcement Board orders liens shall remain co-equal with the liens of all state, county, district, municipal taxes, superior in dignity to all other liens, titles, and claims until paid. 7 years and 9 months later is when the Gauthiers, Robert and Carol Gauthier, executed the mortgage here. And in that mortgage, it explicitly states that it's subject to the laws of the local jurisdiction, including Ordinance 97-07. And I point to definition subsection H, applicable law, which says that applicable law means all controlling, and I'm reading the pertinent part, local ordinances. Later on, paragraph 16, in the uniform covenants of the mortgage, it states that this security instrument shall be governed by the law of the jurisdiction in which the property is located. The property is located within the city limits of the city of Palm Bay, therefore it's subject to this law, and this law wasn't retroactively applied. Roughly 8 years later, the mortgage was entered into, and these terms were contained within the agreement itself. Also,
Does that make a difference?
I think it does, Your Honor. I think that
If the mortgage didn't say that it was subject to the law, does that make a difference?
Well, Your Honor, then I would defer to the implicit understanding of lex loci contractus, which the Supreme Court has stated in Shaps versus Private Life and Accident Insurance
So the
Company.
result would be the same whether the mortgage incorporated the law or not?
Yes, Your Honor. I think it's just on a twofold basis that they understand that they are subject to a local law. They understand explicitly by their very own instrument, which they drafted, and they also understand under the principle of lex loci contractus that they're subject to.
It's irrelevant, right? I mean, you say you've got an ordinance, and this is the law, and it's binding on anybody whether they have recognized it and incorporated it into the instrument or not, right? That's your argument, right?
Yes, Your Honor.
Okay.
Now,
And,
that person, if they looked at 695.11, the lender would say, well, we win. But if they look at the city ordinance, you'd say they should recognize that they lose.
you can construe the argument that way, if, as I said, if you viewed 695.11 in a vacuum, but if you look at the ordinance and you see that it was promulgated, it says in the ordinance itself, this is promulgated pursuant to the city's home rule powers and Chapter 162 Florida statutes, in particular 162.03 subsection 2 and 162.13, which expressly provide for the city to create its own code enforcement system through an ordinance, which is done here. Your Honor, I'd just like to point to, and I'm sure the Court's familiar, that the city has, pursuant to its home rule powers under Article 8, Section 2B, the right governmental powers to enable them to conduct municipal government, perform municipal functions, and render municipal services, and may exercise any power for municipal purposes except as otherwise provided by law. And Section 166.021 further delineates that power, particularly subsection 3 of that statute. And it's in that statute, it says the legislature recognizes, pursuant to the grant of power set forth in Section 2B, Article 8 of the state constitution, the legislative body of each municipality has the power to enact legislation concerning any subject matter upon which a state legislature may act except in 4 delineated provisions. And it's the city's position that none of those are applicable here. The first is annexation, merger, and exercise of extraterritorial power. We're not trying to do that here. Any subject expressly prohibited by the Constitution that is not expressly prohibited by the Constitution. Number 3, that any subject expressly preempted to state or county government by the Constitution or by general law. Our argument, and I'll delineate that further, is that it's not. And 4, any subject preempted to a county pursuant to the county charter. And that's not, the Brevard County Charter does not prohibit us from enacting this ordinance. And then of particular import, subsection 4 states the provisions of this section shall be so construed as to secure for municipalities the broad exercise of home rule powers granted by the Constitution, and it's further the intent of the legislature to extend to municipalities the exercise of powers for municipal, governmental, corporate, or proprietary purposes not expressly prohibited by the Constitution, general or special law, or county charter, and to remove any limitations, judicially imposed or otherwise, on the exercise of home rule powers other than those so expressly prohibited. Now, going through, as I did in my brief, the various statutes, 162.02 authorizes municipalities like the city of Palm Bay to create code enforcement boards with the authority to impose fines and other non-criminal penalties, which we've done here. 162.03 provides for the authority for Ordinance 9707 by reading in pertinent part.
Does the Constitution expressly prohibit a local government entity from enacting an ordinance which is contrary to a state statute?
Yes, I don't find that that's the case here, though I don't believe that we have, and also by the statute say that if they have taken up all the air in the vacuum and there's no ability for the city to legislate in that area, or if they have expressly preempted it, or if this ordinance were to in any way conflict with the state statute, then that would be the case. But based upon the construction of all the statutes together, and particularly Section 166.021, the entire Code Enforcement Chapter 162, Statutory Scheme on Code Enforcement, and also 197.522.
See, that's the problem I'm having, say, unless they conflict. It just seems to me that under 695.11, the lender wins. Under your ordinance, the city wins. That, to me, seems like a conflict.
Your Honor, I think that if you were to construe it that way, then 159.17 conflicts because that says the utility lien is superior.
But that's a conflict between two statutes, which then you apply rules of statutory construction to reconcile them. Here we have a statute versus an ordinance.
Well, I understand. I mean, Your Honor, I would point in that case to 162.03 subsection 2 and also 162.13 for the proposition that the city is allowed to promulgate ordinances on this particular area.
Right, but neither of those expressly authorize, either of them expressly authorize a city, if they wish, to enact an ordinance which gives a code enforcement lien priority over a pre-recorded
I understand, and I would argue also that neither expressly preempt the city from doing what it's done here.
Right, so if it doesn't prohibit it and doesn't authorize it, then why don't you go back to 695.11?
Because the city has, under its home rule powers, it's able to legislate in this way. And so the city purposely, in any code enforcement scheme, I mean, the purpose of code enforcement, as you know, is to go and protect the very collateral that the appellee has secured by the mortgage instrument here. And we spend an inordinate amount of time to make sure that the city's code of ordinances are complied with. We have these mechanisms in place in Ordinance 9707 in order to do that. And we're expressly allowed to do so under 162. And so if we didn't have this kind of ordinance in place, then a lot of the effort and the expenses incurred in protecting the very collateral that the appellee is trying to foreclose upon would be all for naught. Your Honor, I'd also like to just go through a couple other arguments with respect to whenever a municipality exercises home rule powers. There's a two-tiered question that arises as to whether it may act in that way. And I think that's directed to a lot of your questions, Judge Evander. Particularly, does the legislation have a municipal purpose, and is the legislation expressly prohibited? Now, with respect to the municipal purpose, as I said, that's laid out in the ordinance itself in Section 1. It's for the health, moral safety, and welfare of the city of Palm Bay, pursuant to the...
Well, I don't have any problem with the proposition that the city has broad powers to enact ordinances and can address a lot of subject matters. But the Constitution provides that, that ordinance cannot be contrary to a state statute. So that's the issue I'm wrestling with, is how is this not contrary to 695.11 when you've acknowledged that the result changes. You take one fact situation, and under the ordinance, one party wins, and if you apply the state statute, the other party wins, and so that's what I'm having trouble with, is how your ordinance is not inconsistent with the statute.
I believe the ordinance is inconsistent in the statute when you take it, as I said, in a vacuum, because it says all instruments, and I think
Could the city enact a statute that says that anytime any of our subcontractors here in the city of Palm Bay does any work on any residences here in the city of Palm Bay and don't get paid, that they can file a lien, and that lien will have priority over the mortgage?
that wouldn't serve a municipal purpose, Your Honor. It doesn't do anything to benefit the citizens of the municipality.
It has to do with, the police power, doesn't it, to protect a citizen who contracts, and why isn't that?
I would view that entirely. I respectfully disagree, Your Honor. I view that entirely differently. That's a contract for services provided, and the only possible argument you could have there is that it deals with the morals, whereas code enforcement deals with health, safety, welfare of the citizens, particularly.
So the city could, as long as it was the city doing the work, if they sent people out and mowed lots or something like that, and they were entitled by ordinance to get paid, could they have an ordinance that says that if we don't get paid for mowing lots, that...
Your Honor, actually, we do have Ordinance 97. Ordinance 2003-26 addresses what we call nuisance
get priority over the mortgage.
Yes, Your Honor, we have that too. And so, as we've noted, we don't retroactively apply that. We apply it after 2003, July 2003. But whenever we have to rectify,
that's legal, right?
Your Honor, I consider it to be legal under the home rule powers of the city. And let's see. And if you don't mind, Your Honor, I'd like to reserve the remaining time.
May it please the Court, my name is Matt Canigliaro. I am with Carlton Fields, and I'm here today on behalf of Wells Fargo, the appellee. The trial court correctly ruled that this ordinance is invalid. In our brief, we set out, I think it's about 5 different reasons why the court was correct. I'd like to touch on ones that have come up already in this argument. First of all, with respect to due process, we have argued in the brief that due process has not been challenged, and that is a basis to affirm. But having said that, I would emphasize that this issue is important to Wells Fargo. It's important to the city. We've seen an amicus appear in this case. It's obvious that these ordinances are out there. And from counsel's argument just now, as I understand it, they're out there in other forms as well. So while we certainly want to win this case and want this judgment to be affirmed, we would prefer that it be affirmed in all respects. And so with that having been said, let me address the merits of the other arguments that we've made. First of all, Judge
So you
Banner,
only want to win on that argument if we say you lose on the other one? Is that what I'm getting from you? You only want to win on that first argument if we say that you're wrong on the other one?
well, I think I would put it that it's a
I mean, do you
substantial
want us to, you want us
fallback
to reach
argument.
the merits of that argument or not?
We would prefer that the court reach the merits of the argument, but ultimately,
Well, only if we move forward.
Then I think you lose the due process argument then.
well,
I think that your reading of the Mennonite case is overly broad.
well, to be clear, I'm not waiving our position taken in the brief that the due process argument reached by the trial court and made by the finding or ruling made by the trial court has not been challenged on appeal properly here. And so
It sounds like you don't want us to rule on that basis.
well, we certainly want to win the case, and on the merits of whether this ordinance is valid or not, particularly the arguments we've laid out in our brief, the first four prior to due process, we would encourage the court to rule on those. With respect to due process, respectfully, it has not been raised in this court, and while it is a fallback of sorts, we think that is a complete and independent ground to affirm the judgment below. And so if the court is to get to due process, and we have raised that as our fifth point in defending the court's order, then I think the answer is...
If there's an issue that hasn't been preserved on an independent basis for affirmance of the trial court, we rule on a narrow basis, not, this isn't an advisory board. We rule narrowly rather than broadly. Wouldn't you agree?
I think the court is certainly empowered to do that, and that often that is the course that the court takes.
Well, if we rule for you on both issues, is the second issue dicta?
I want to make sure I understand Your Honor's question. Do you mean the due process issue?
Well, no, if we say the due process issue was not preserved, therefore we affirm, then while we're talking about it, let's talk about the priority issue, and if we agree with you, is that all dicta?
I think depending on how the court framed its decision, it might be or it may not be. I think the court can reach decisions based on alternative grounds. But I do want to be very clear that we are not waiving the objection that due process the court's due process ruling is not challenged here on appeal, and that is a complete and independent basis to affirm this judgment.
Yeah, I had trouble with your argument in the brief about this is punishment, extra punishment.
Penalty.
Or extra penalty, if you would. Who's being penalized by this ordinance?
Well, in some respects, the mortgagor and the mortgagee are being penalized. And certainly here as the mortgagee, we're making the argument that the super priority notion that is advanced by this ordinance is a penalty.
Well, how is the mortgagor being penalized?
Well, that's...
They have to pay the same amount, it's just a matter of who gets paid first, but how are they being penalized?
Well, first of all, it's a lien being put on the mortgagor's property, and this affects the character of the lien that's being put on the property.
But the placement of the lien isn't, your beef. Your beef is the prioritization of the lien.
That's true, Your Honor.
Okay. So that's got to be the focus of the penalty. And I'm trying to understand what authority you're arguing that the prioritization of a lien constitutes a penalty. What authority do you cite for that proposition?
Well, the City of Tampa versus Braxton case expressly held that 162.09 is a penalty provision and must be strictly construed. And so our position is that it is a penalty. It does reach beyond just the mortgagor to us, the mortgagee. but that it is in fact a penalty. And if, I would ask almost rhetorically, if it's not a penalty, then what is it? It is a remedy that the city has taken upon itself to give itself priority over mortgagees such as Wells Fargo in this case. And that is exactly what the courts have said cannot be done. And I would quote from the Stratton versus Sarasota case, the second DCA case, saying the county has no authority to impose penalties that are not authorized by law. And in this case, that's what's happened. I mean, it's when the lien is imposed and it becomes a lien with super priority, then that is a penalty that has come from what began as a code violation. And without statutory authority in Florida law, that penalty is not authorized. And it must be a penalty because it is relief. And I do acknowledge the penalty reaches beyond the mortgagor to us as the mortgagee, but nonetheless we maintain it is a penalty. Going back to Your Honor's questions about 695.11, we agree that the first-in-time rule is the default rule. It is a statutory rule under Florida law, and that this ordinance is attempting to essentially override that through this code enforcement scheme. And as we've explained in the brief, we sort of couple that with the language of 162.09 sub 3 itself, where it says that the lien to be imposed is one that is enforceable in the same manner as a court judgment. As we explained in the brief, court judgments are become liens upon being recorded, and they are subject to the first-in-time rule. And for that additional reason, this is an attempt to contradict and conflict with what Florida statutes say is to happen, both concerning first-in-time with recording of liens in general and with recording of court judgments, and this statute in particular. So for each of those reasons, we have conflict here between the state statutory scheme and this ordinance. We have also argued at some length in the briefs what is sort of a mix of express and implied preemption based on 162.03's subsection 1's provision that municipalities are authorized to adopt or create or abolish code enforcement schemes as provided herein. And that language, as provided herein, has been interpreted numerous times by the Attorney General, at least once in an opinion that the second DCA in the City of Tampa versus Braxton case said we agree with the conclusion there, that as provided herein means you take it or you leave it as it is, that alternative methods of enforcement are available, but they are alternative methods that don't come within this scheme. And if a city or a county wants to adopt an alternative method, then it would have to rely on the county court system to enforce it. And as has been concluded in numerous Attorney General opinions, which we have cited to the court, and in the City of Tampa versus Braxton case itself, by recognizing the Attorney General's language and saying, we find persuasive the Florida AG's opinion 92-73, which states that municipalities derive no home rule power from Article 8 to impose any duties or requirements on their code enforcement boards or otherwise regulate the statutorily required enforcement procedures. And what that means, in essence, is if you adopt Chapter 162's enforcement scheme, you must do it in full, that you can't then adopt it in part and change it, and that's exactly what the City of Palm Bay has done here. They've adopted it and then tried to change one particular aspect, and it's this lien provision, which is extremely important, and in this case has adversely affected our interests. And
well, there are other differences in what they adopted as well, with the size of the board. Yeah, there are some other differences. And your claim is that they can't alter it at all?
Well, our argument, Your Honor, is that as provided herein means you must adopt what has been laid out in the statute itself. And I'm not aware of what other differences there are in this case, and I don't want to speak to them, whether they be valid or invalid. But we do maintain that with respect to the enforcement scheme and what, in particular, what relief the city can avail itself of when violations are found, that is not something that the city can determine for itself. And it really leads me into my next argument, which is that the specificity of 162.09 subsection 3 is such that this effectively preempts the field of liens in this context. We have a very substantial statute which gives extreme detail about when this lien can be created, who it is created in favor of, how it's to be enforced. The paragraph is substantial in its requirements and its provisions, and it does not leave room for the city to come in and change the lien. And that's what's happened here. And because of that, the legislature has, at least in this extremely narrow area of the lien, preempted this area. And we think that is just yet another reason why.
Your argument, it's not an express preemption, it would be an implied preemption.
In that instance, yes, Your Honor, it would be implied. But we've made numerous express preemption arguments as well. And as I started out saying in the beginning, in line with 695.11, which is the first-in-time rule, that here we have first-in-time, we have a lien that's enforceable as a court judgment, which is given first-in-time priority and not a super priority, and that because of that as well, we have a direct conflict between what the ordinance says and what Florida's statutory scheme says, both in the big picture of 695.11 and with respect to this act in particular, and how the lien scheme functions. Ultimately, we believe that the trial court was correct in determining that this ordinance is not valid. We urge the court to affirm the judgment below. With respect to due process, again, we urge the court to determine that the issue has not been presented, it's not been preserved, has been waived, and that constitutes an independent basis to affirm below. With respect to the other arguments made on the merits of the validity of the ordinance, again, we ask the court to affirm the trial judge correctly determined that this ordinance is not enforceable.
Thank you.
All right, thank you, counsel. All right, you got a little bit over a minute, sir.
Okay. Thank you. I just want to touch, my name is James Stokes. I'm the city attorney and co-counsel with Mr. Lannon. And I just wanted to kind of wrap up a couple points that were brought up. First of all, regarding whether or not this fits in with 162 and whether we've changed 162. Understand, Chapter 162 provides for a mechanism to bring properties into compliance with the code through a mechanism. We follow that mechanism through warnings, through notice violations, through hearings, and through an imposition hearing, and ultimately it becomes a lien. Once something becomes a lien, which is a long process to get there, and the property owner has lots of opportunities to cure, once it's a lien, it's an asset of the city. And what we're dealing with here is how we collect on an asset of the city. We are not touching the statutory structure of how these cases are adjudicated. What we're dealing with here is how we collect an asset that belongs to the city. And the Attorney General has even opined that code enforcement boards don't even have a jurisdiction to revisit an issue once it goes to lien. There was a question asked whether or not a reduction, code enforcement board could be approached in order to reduce a lien. Attorney General says no, they have no jurisdiction. Once it's a lien, it's done. The other thing on...
We're out of time.
Okay.
Sorry, that's how much time he saved you, sir. The council didn't even use all his time. All right,